Senator Lucchini, we've got inappropriate use of the Q&A. Could we do something about that?
Sure. Yeah, we can remove that message. And if people continue to do inappropriate stuff in there, we'll remove you from the meeting. So.
Thank you.
Yep.
Come on, Louis. I didn't even get to read it.
Thanks for flagging. And good morning, everybody. Welcome to the Committee on Veterans and Legal Affairs. Today, we've got a number of work sessions scheduled. But before we get into those, we'll begin with committee introductions. We'll start with House Chairman Chiazzo.
Thank you, Mr. Chair. Good morning. Happy Monday. Chris Chiazzo, House District 28. Beautiful, sunny, and chilly this morning, West Scarborough, Maine.
Okay, Senator Farron.
Good morning and happy Monday and happy birthday, Senator. Just wanted to put that out there so everybody knew. I'm Brad Farron. I live in Norridge Walk and represent Senate District 3, which is the majority of Somerset County in the town of Rome and Kennebec County.
Thanks, Senator. I'm getting old as it is. So Representative Riley.
Hi, Representative Riley. I represent House District 34, which is part of Westbrook.
Okay. Representative Wood.
Good morning. I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland, where it is sunny and a little chill in the air.
Representative Supika.
Good morning. I'm Laura Supika, and I represent House District 126, which includes a portion of Bangor.
Okay, Representative McCrate.
Good morning. I'm Jay McCrite, representing Harpswell, West Bath, and Northeast Brunswick in the House.
Okay, Senator Hickman.
Good morning. I'm Senator Craig Hickman, representing District 14, 11 towns in southern Kennebec County, including my hometown of Winthrop. And congratulations on your birthday, Mr. Chair.
Thank you. Representative Harrington.
Good morning. I'm Representative Matt Harrington. I represent part of the city of Sanford in House District 19.
And Representative Corey.
Good morning. I'm Patrick Corey, represent House District 25, which is part of Wyndham.
Okay, Representative Tuttle.
John Tuttle, District 18, the other part of Sanford.
Great. And with us, we have our committee clerk, Karen Montel, and our committee analyst, Sam Prower. And I think Janet will be with us. Our other analyst, Janet, will be with us later on in the afternoon when we get to budget stuff. But so today we do have 5 work sessions scheduled. So Sam, if we can start with LD 1589, an act to ensure equity in the cannabis industry, please.
All right. Yeah, I just had a moment where I temporarily forgot how to share my screen. Let me pull it up. There it is. All right, can everybody see this?
Yep, looks good.
Great. So this is LD 1589, an act to ensure equity in the cannabis industry. So originally this bill was a concept draft. So what I've done in the bill analysis is provided the committee with a, with the analysis of the sponsor's proposed amendment from the public hearing. And as I have done with the other marijuana bills, you have a link up at the top here to the electronic LD file with the testimony, and also a link to the section of law that's being amended by the bill. So I'm going to read the summary, and then I'm going to just go down through a couple of the things that are changed in the bill, because the summary is not quite as specific as the actual changes are. So this amendment changes the membership of the Marijuana Advisory Commission established under Title 28B, Section 901, by increasing the number of members from 15 to 21 and specifies additional members representing certain interests. And I'm going to scroll down, and as you can see, the these members here for subparagraph 4, 5, and 6 are additional members to be appointed by the President of the Senate. And then the members here in Part I, subsections 4, 5, and 6 are appointed by the Speaker of the House. And this bill also adds a provision that requires that for all appointments under the made, an effort must be made to represent racial and gender diversity of the state of Maine. And the final piece this bill does is it changes the what constitutes a quorum, and that's just to be updated. It's updating the number based on the addition of members. So the changes that were proposed in this amendment are similar to those that were proposed in LD 2091 from the 129th session. That was passed by this committee, but ultimately didn't make it through due to the early end of session. The changes are similar to those from 2091, but are a little bit different. So, for example, this addition here was not in LD 2091. And then if we go back up to the appointments for the President of the Senate, subparagraph 6 is worded slightly differently from LD 21. And I have an excerpt from LD 2091 if the committee would like to see it for comparison. But other than that, that's what I've prepared for you, unless there are any questions.
Great, thank you, Sam. Any questions from the committee on the overview and analysis of 1589? Representative Corey.
Thank you. Thank you, Sam. Do you have a list of the people that are already on the committee without the appointments from the governor, or not the governor, but the president of the Senate or Speaker of the House? I know there's a few members that are there because they're a part of different parts of state government.
I do. I need to find where it is in my files. I will say that for the members that are part of state government, my current list doesn't reflect whether they've changed with like the way the administration's changed. So I don't know if the current commissioners or commissioners designees have been.
Oh, I don't care. I don't care about the individual people. I care more about what those appointments are, or not those appointments, but those positions on the committee are. And then, did the committee last year strike any members from the committee in that bill, or were those just additions to the people on the committee?
I don't believe the committee last year struck any of the members. And let me pull up the bill analysis again, because I have it shows which departments are involved.
Okay.
Yeah, I don't think we struck any. I think we just wanted to add for broader perspective, but I can't remember for sure, Representative.
We didn't strike anything.
So so here is these are basically this is the list of agency representatives that were meant to be on the commission. And then if you would like, I have the excerpt from the bill from last session. I can show you.
Sorry, Sam, can you run us through maybe just the list in total on that? Just from the top,
yeah,
so people can see.
Sure.
Thanks.
Sure. So the membership it is currently 15, but this bill would change to 21 members. So that's 2 members of the Senate, including members from each of the 2 parties holding the largest number of seats in the legislature, appointed by the President of the Senate. And then the same for 2 members of the House of Representatives. It includes the Commissioner of Administrative and Financial Services, or the Commissioner's designee, the Commissioner of Agriculture, Conservation, and Forestry, or the Commissioner's designee, the Commissioner of Health and Human Services, or the Commissioner's designee, Commissioner of Labor, or the Commissioner's designee, and the Commissioner of Public Safety, or the Commissioner's designee. And then currently there are 3 members appointed by the President of the Senate, 1 representative of a statewide association representing prosecutors, 1 representative of a statewide association representing the medical marijuana industry, and a member of the public. And then there are also currently 3 members that are appointed by the Speaker of the House, which would be a representative of a statewide association representing the adult use marijuana industry, a member of the public with demonstrated expertise and credentials in public health policy, and a member of the public. And then the rest of these are ones that would be added by the amendment. And would you want me to read through those as well?
Yeah, sure. That'd be helpful, I guess. Thanks.
Yeah, so the 3 additional members that this amendment would add to be appointed by the President of the Senate are a member of the public with demonstrated expertise in the cultivation of marijuana or the manufacturing of marijuana concentrate and marijuana products, a representative of a statewide association representing defense attorneys, and a representative of a statewide civil rights organization with a primary mission to advance racial equity and racial justice. And then the additional 3 members that would be appointed by the House of Representatives, the Speaker of the House, would be a qualifying patient, a member of a federally recognized Indian tribe in the state, and a representative of the main chapter of a national civil liberties organization.
Great. Thank you, Sam. Representative Corey, did you have a follow-up?
I am trying to look at right now sort of how DAFS is organized. Is DCD under DAFS?
I would remember to check. I can't remember off the top of my head.
Not correct, right? So here's, can we just go back to that government list real quick? Because I'm really kind of thinking about how I'm much more concerned about that list than I am about the other.
Yeah, so I did just quickly look up DCD. I think that's separate, and that's under Commissioner Johnson. And then
Yeah, for some reason, and for some reason the governor's DCD website is down right now. So here's what I would probably like to see is that I do see that the Commissioner of Administrative Financial Services or the Commissioner's designee, I'm guessing that's the head of OMP right now. And we would have to look into that, but I'm guessing that's who DAFS has there. Then I go to the agriculture, conservation, that makes sense to me. Health and Human Services kind of makes sense to me considering, some of the issues surrounding, health and everything. The Commissioner of Labor or the Commissioner's designee, I don't know why we need this there. Like, I'm wondering if it would make sense to have somebody from Department of Economic and Community Development there instead. And I'm saying that because, I think that the outcry we're hearing from these businesses, at least, is that they want to be, treated like businesses. And, they say that they have, the second largest, cash crop in the state of Maine. So I'm wondering if we put somebody from the Department of Economic and Community Development in that labor slot, only because I think it probably makes a little bit more sense. With regard to, the Commissioner of Public Safety being on there, I'm not even sure how I feel, about that slot being there. I know that, last year they had pushed in the budget trying to put, DEA agents in the Office of Marijuana Policy. And, we definitely decided not to do that, but I'm trying to figure out the public safety piece there, other than, if we're looking at things like impaired driving and stuff like that. But, if we are looking at those things, then you're talking about the Bureau of Highway Safety, and that falls under the Secretary of State's office, correct? Do you know, Sam? Or
Oh, sorry. Yeah, I believe Bureau of Highway Safety is under Department of Public Safety, but I could be wrong. I can check when I stop sharing my
DOT.
screen.
It's under DOT because they're the ones I think that usually weigh in on those, do you know what I mean, impaired driving things and everything. That's why I'm not sure why public safety is there. I don't know. I'd be curious to see what the committee thinks of my mashup there and kind of my thoughts. Anyways, thank you.
Yeah, and Representative, I just quickly Googled, it looks like Bureau of Highway Safety is under Public Safety.
Okay, then that could make sense to me if Bureau of Highway Safety is there, but like I said, I would switch out the labor one for Department of Economic and Community Development, where, you know, they want to be treated like, you know, businesses. So I think it would make sense to look at it as economic and community development, which it is for Maine right now.
Yeah, I agree with DECD. I think this has become a very big economic driver, so they should have a place on there. Representative Wood?
Thank you, Mr. Chair. I just wanted to speak about my support for all of the people that have been added, but in particular, I've been advocating to have, let's see how it's worded, a member of the public with demonstrated expertise in the cultivation of marijuana or the manufacturing of marijuana concentrate and marijuana products. I just feel like the commission has people that represent the industry, but there's been nobody who actually participates in the industry, like I like to say, get their hands dirty. So I have wholehearted support for all of the changes, but in particular that one, and also the change in title of the bill, I think makes a lot of sense that as this evolved, it really is about membership of the Marijuana Advisory Commission and not just the cannabis industry. I also like what Representative Corey was saying as far as the Department of Economic and Community Development, and I'm wondering if I can make a motion ought to pass as amended with what Representative Corey wanted to change, moving labor out and moving economic and community development in.
I'll second that motion.
We have a motion about to pass as amended by Representative Wood and seconded by Senator Hickman. Further discussion, Senator Hickman?
I just agree that the Commissioner of Labor should be removed and replaced with the Commissioner of DECD or her designee.
Can you say that again? Sorry.
I just agree that the Commissioner of DECD or her designee should replace the Commissioner of Labor or her designee in this commission at this time. I think that labor was there, public safety was there. This was a standalone bill that was incorporated into LD 1719, and many of the issues that may have been talked about were settled in the law, so that the Department of Labor's participation in this as an advisory board is really not necessary at this time.
Yeah, I agree with that. I think now it really is an economic driver that should be, DECD should be in there. Any further discussion? Okay, seeing none, the motion before us is ought to pass as amended. And Karen, if you please, we can proceed to a roll call. Oh, sorry, I think we have a question first. Representative Corey.
Thank you, Mr. Chair. What was the title of the bill going to be again? Were we changing? Did we have to change the title of the bill? I remember just hearing somebody say something like that, and I didn't hear that as cited as any part of a motion.
My apologies for not highlighting it when I read the bill analysis. The title of the bill would be, as part of the proposed amendment, would be an act to ensure equity in the membership of the Marijuana Advisory Commission.
Okay, gotcha.
I mean, I don't care either way, but I wasn't sure if we had to change the title based on what we were doing, but okay.
Seems to work. Senator Hickman. Senator, I think you're muted.
The title is changing because what we are dealing with, the strike and replace amendment, is completely different than the original bill, which had to do with equity across the industry in other ways regarding licensing, access to licensing, delivery. It's just a different bill. So the title reflects what we're actually doing with the bill. And that's why it's changed.
Thank you.
If that makes any sense.
Okay, any further discussion? Senator Hickman, did you have another, or are you good? Okay. Okay, seeing no other questions, the motion before us is ought to pass as amended. And Karen, if you can please call the roll.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney, absent. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. 11 in favor of the motion, 0 opposed to the motion, and 2 members absent, Mr. Chair.
Great, thank you, Karen. So we've got that. We'll close the work session on LD. What's that? 1589. Okay, next up, we'll move down the list to LD 1242.
I believe Representative Corey might have his hand up.
Sorry, Representative Corey.
I saw Representative Kinney appear down in the corner the second, or just right before we closed that vote. I don't know if we need to ask her.
I probably should
Representative
call in
Kinney.
later. I should
Okay,
call
yeah, I was
in
gonna-
later because I came in, nobody was voting at all anymore.
Yeah, okay. Yeah, I don't want to put you on the spot. If you don't. Yeah, great. So let's move to LD 1242.
Would you like me to pull up the bill analysis for a quick refresher and then hand it
Yeah,
over
if
to
you
you?
don't mind, that'd be
That's
great. Thanks.
great. All right, so you should all be able to see this now. So as before, this is the bill analysis I had done for LE 1242 alongside 1319 because they address similar issues. As you'll remember, the big changes in LE 1242 were that it changes a lot of the department's rulemaking authority from routine technical to major substantive. I'm not sure if you guys would like me to walk through the entire summary again. I'm very happy to, but I also know that Senator Lucchini has introduced an amendment at the previous work session and may have some additional changes.
Sure. If you want to do a quick overview of the 1242 points, that would be maybe perhaps helpful for people to refresh, and then I can show the amendment after if people want to see it. Yep.
Perfect. Okay, so LD 1242 does the following. It changes the designation of rules governing medical use of marijuana from routine technical to major substantive. It provides that the Department of Administrative and Financial Services rules governing the medical use of marijuana are those that were last amended February 1st, 2018, and that before adopting or amending rules governing the medical use of marijuana, the department must establish a process to include caregivers, registered caregivers, and patients and physicians and certified nurse practitioners with significant knowledge and expertise certifying patients under the laws governing the medical use of marijuana in the development of these rules or amendments, and must consult with caregivers, registered caregivers, patients, physicians, and certified nurse practitioners. It requires the department to develop a process to retain any consultant hired to advise on rule changes related to the laws governing the medical use of marijuana, and report on the development of this process no later than September 1st, 2021, and report on any subsequent changes to this process to the Joint Standing Committee of the Legislature having jurisdiction over health and human services matters, so not this committee. Fourth, it eliminates the requirement that a registered caregiver, a registered dispensary, a marijuana testing facility, or a manufacturing facility complete an annual audit conducted by a third party of business transactions, and this is an overlap portion with LD 939, which also has not been voted yet. And fifth, it eliminates the requirement that the department develop and implement a statewide electronic portal through which registered caregivers, registered dispensaries, marijuana testing facilities, and manufacturing facilities may submit certain records to the department. And then before I go on, I'm just going to scroll down to the bottom. I can't remember off the top of my head if I had additional notes for the committee. Yes, I just had a few notes for the committee regarding the bill as drafted. These were mostly about the consultant process that's to be developed, and just it was unclear to me from reading the bill what kind of process and retention must happen and whether these consultants would be hired or what that process would look like. So if the committee wants to move forward with the bill as drafted, I would recommend providing a little bit of further direction there.
Great, thank you, Sam. I guess, would you be able to pull up the amendment and I can just kind of walk people through and see their thoughts?
Okay, would you like me to pull up the one with the additional with some additional information? Okay, yeah. Great. So, and I can walk through it if you'd like.
Okay.
As well, or you can walk through it if you prefer that. I don't care. Either way.
Yeah, either way you can if you'd like, and then I can jump in periodically, explain why. Yeah.
So many of the committee members will recognize this is similar to what Senator Lucchini had proposed at the last work session, but there are a few updates. So this is a bullet point summary of Senator Lucchini's proposed amendment to LD 1242. So it would make the following statutory changes regarding the medical marijuana program. It would remove the independent audit requirement in section 2430G. It would add the single card language provided by OMP, so it would bring all the registrant cards under one card. And I also have that language from OMP available to screen share if you'd like to see it again. Third, it would allow caregivers to sell plants to patients. And fourth, it would add to section 2430G, paragraph B, the language that the statewide electronic portal shall not contain the names or dates of birth of qualifying patients.
Sure, and that's a new one that I added in. Sorry to jump over you, Sam, just so people know, because I've talked obviously to a number of people in the industry and concerns about the portal being able to identify patients. Obviously, we want nothing to be identified, like to tell you who the patient is. So I am proposing adding that into the law, actually, not into the rule, but into the law. So sorry, Sam. Yeah.
No worries at all. Just continuing, it would direct OMP to change its proposed rule that is currently working on as follows. It would direct the department to remove the video surveillance requirements for home-based caregivers. It would direct the department to remove the security system requirements for home-based caregivers, remove the lighting requirements, remove the video and security requirements for caregiver dwelling units broadly. It would remove the car alarm requirements, and remove references to law enforcement. And it would direct the department to create exemptions for small caregivers from the track and trace system. And it would direct the department to create more flexible reporting plan for metric if, for instance, it were to go offline or if a registrant were to lose their internet connection. And it would direct the department to develop specific rules for marijuana tincture and marijuana drink. And it would also provide some additional statute changes to specify that the department may not, and I believe these are new since last work session.
Yeah,
so
I can kind of explain these if you'd like, since you sprung it on you here.
Yeah, if you would like, and I also I realized that from last time I didn't do like I didn't provide the committee with some like as much analysis of these as I could have. So I'd also like to just provide some helpful notes for making some of these changes if that works too.
Yeah, thank you. Yeah, that would be great. And I would just to cover those last two bullet points that I added in since last time. So this is new. Just again, from conversations with a lot of caregivers, there's just concern also about the time of implementing the track and trace program. And so, I mean, some people wanted just to delay it for the sake of giving more time before you implement it. And so this would say that the department can't enforce track and trace on retail caregiver storefronts until 2022. So it's January 1, 2022. And it gives more time for home-based caregivers. So that would say that the department can't enforce track and trace on home-based caregivers until June 1st of 2022. So that gives a full year for the industry to get ready for this. And my hope is that through a different vehicle, we can get all stakeholders and the department together to work through this and all the other various underlying issues and come up with something and bring it back to us in January. And then we can make those changes. I mean, we can see if there's agreement, see if there's changes for a new bill, because I think we need to essentially, I think the relationship between the industry and regulators is unsustainable, and that people need to get together, work out solutions, and then we'll be able to hopefully make a better program, all encompassing. So we'll be able to look through the law, the underlying law, which is a lot of what we've heard feedback on is the law itself, not so much the rule, but issues with the law. So hopefully we can get that done, and hopefully we can do it with this expanded advisory commission, which we just formed. So this would give us time. We wouldn't do track and trace on home-based caregivers until June 1st of next year. So Senator Farron.
Thank you, Mr. Chair. As I think we all know, we've all been receiving a number of emails and comments, and I appreciate the work you've been doing trying to get out there. A couple notes that I took over this weekend looking, and again, I apologize if I'm asking questions that hopefully somebody can answer very quickly, because there's a lot to this. One of the comments I heard back from the caregivers was that there wasn't a distinctive definition of a home-based caregiver. Is that something that I'm missing?
Yeah. Yeah, no, I've heard a lot about that. And Sam, if you have the rule, could you call up the rule? So that's not a defined term in statute, but home-based caregiver is defined in the rule. And what I've found is, just over the last week, when I've explained this to people and showed the language of the definition, people are a lot more comfortable about it, because I think under the definition in the rule of home-based caregivers, I think this will encompass probably like at least 85% of caregivers. So Sam, can you read it out in case people can't see it?
Absolutely. So This is in the department's proposed medical marijuana rule. And it reads that a home-based caregiver means a registered caregiver who engages in all authorized cultivation and manufacturing activities at the registered caregiver's primary residence and who does not operate a caregiver retail store. A home-based registered caregiver must comply with all applicable requirements of the Act and Section 11 of this rule. And I don't want to cut anybody off, but this kind of speaks to just one thing I just don't want to let get away from me here in talking about these like proposed changes to this proposed direction to give the department to change their rules. I think if the committee were to move forward and direct the department to make these changes, it would be helpful to actually put a definition like this in statute. That way that the resolve actually has reference to something that's solidified in Maine law. And I think that that's true for like a lot of the changes that would be directed at the department through this amendment. It would be it's helpful to have actually like the authority altered in law as well, just to make it as clear as possible, like moving forward, and also make it easy to identify where the changes came from in the future. So that would just be a drafting recommendation for the committee. You're not absolutely required to do it that way. It's as much, if you're going to tell the department to change the rules, it's helpful to clarify it in the actual rulemaking authority alongside that as well.
Great.
Follow up, Mr. Chair.
Yep, Senator Farren.
And also, I guess one of the things, this probably goes to the director, is that, we had these rules, we've gone, this has been moving and we've been working on this. One of the things I have heard from the community as well is some concerns at the staffing at the Office of Marijuana Policy, and it takes upwards of 30 so days for license renewal, and we're talking about these rules and the implementation, and it looks like more work. And I guess at some point before we go to a vote, I wonder if we might be able to hear from the director and just kind of get his thoughts on the staffing piece and how this would all work with them.
Yeah, and thanks, Senator. I think we're bringing in the director if it's under Gabby Pierce. Okay, welcome, Director. Did you hear the question? I can fix the name thing.
Yeah, I did. Thank you for the question. A lot of it has to do with the turnaround times from when in 2018, the legislature allowed caregivers to have unlimited assistance. And in the past, they were limited to the amount of assistance. And when they allowed that, there was a significant jump, thousands of assistants across the state, yet the process the department went through to register those assistants didn't change. And that's why we're supportive of the one card system, to help alleviate a lot of that administrative work and make sure that we can turn those around more quickly.
And Director, are you good, Senator? Yeah, Director.
Thank you.
So related to the rule, which I don't have up at the moment, but there was concern just that the term home-based caregiver could be subject to interpretation or something, but essentially a home-based caregiver is somebody who does all their operations at their residential property, correct? And doesn't have a retail store.
Correct.
And so under the amendment that I offered, because most of them are governed under Section 11 of the rule, those people would not have to have any video surveillance, any security systems like the ADT things that talk, any of the lighting requirements for anybody who does everything on their home residential property. Is that your understanding of the?
That's my understanding of the amendment. So those home-based caregivers anywhere on the property would not be required for the video surveillance, the lighting, and the alarm systems, correct?
Right, and so that applies to outbuildings, that applies to cultivation areas. What I'm recommending, not the rule, but what I'm recommending would get rid of all of that.
Right, so if there was a standalone garage, barn, greenhouse, anything like that on the property, they would be no longer subject to those requirements.
Right, okay, thanks for just clarifying the interpretation side of it, because that is honestly the loudest thing I think I heard from people was the cost from video surveillance, not just, around, but also at their outbuildings, their cultivation areas. So this would remove that. And if we do move ahead with this, Sam, I would just, hopefully we can use your expertise on making sure that none of the rules under section 6 would accidentally impact the home-based caregivers. Representative Corey. Oh, sorry.
Thank you, Mr. Chair. I still have a concern with the direction we're moving in here. It's still my belief that, the original bill, talks about, making the rules major substantive. I honestly, I've heard what, people's concerns about the rules are. I think that, Senator Lucchini certainly has addressed some of those concerns. I'm still hearing from other caregivers saying that all of those concerns, aren't being, addressed even within that section of rules. I've been very focused on what the actual, bill is trying to do, what the differences are between, this bill and the bill that tries to put a moratorium in effect. I mean, we're dealing with, 90 pages of caregiver rules. I'm really only comfortable, personally, going ahead and making the rules, major or substantive and reviewing them, in next January once, the Marijuana Advisory Commission has met, once all the different stakeholder groups have met. And lastly, with Metric, I have real concerns about, whether or not this is financially feasible for caregivers to implement. I know that we're talking about a delay on implementation for the smaller home-based businesses, but, I had asked Director Gunderson whether or not, anybody in the adult use market had, applied to be in that lowest tier, the 500 square feet or 30, plants. And, I think his answer was very few, not being able to put his hands on it. So I really don't even know if there's much economy of scale sort of within that tier. So without, having, some kind of a, report, about the, financial feasibility of implementing, number one, all of these rules, and, number two, the metric system, I have a lot of reluctance right now deciding what a small caregiver is or a large caregiver, or whether or not we're addressing every concern everybody has. And I know that this is moving forward in a lot of ways, but I'm uncomfortable doing this at the very end of session, and frankly radically changing a bill to this extent, where we would actually be looking at the rules themselves, even though we're not talking about that within the bill right now. So anyways, that's where I'm at. Sorry for the long-winded response, but I'm not sure that this is the time or the place to hash this out. Thanks.
Sure, and I can speak to the reason why I've put this forward is I think we've talked about in previous meetings, is that we have two bills on rules right now. If they both fail, the rule goes into effect in full. And so my amendment on this bill, I view as basically an insurance policy for people, that you can do whatever you want in the other bill to delay the rules, do whatever you want, swing for the fences in LD 1319. But this one would serve as a backstop in the event that that other bill doesn't pass. Then we have a much more manageable rule for the industry going forward. It's pretty much a backstop, because the reality is if neither of these bills pass, the rule goes in place in full. And so this is kind of the safety valve, I guess, that would, in the event that we can't get broad support to do this, and we don't know, where the chief executive stands on this, but typically they support their directors. So that's my thought, is that this is something that can give a safe alternative, and then the other bill can go for everything for people who want to take that route. Sam.
I just wanted to say one thing I hope might be helpful for the committee in making your decisions is that you don't necessarily, in fact, I would probably recommend not going through and trying to say change, section, 5 paragraph, whatever of the bill, like going through line by line. And instead, in whatever direction, if you were to move forward with this, to give, is more effective to give kind of broader guidance to the department. So you could say the department, must remove or must exempt home-based caregivers from, certain provisions, and then let them kind of figure out how, like, where in the rule they have to strike things. That will just save you from missing something, and it'll still have the force of, the force of law. This will have to make all those changes. I think I just want to encourage you not to try to go through line by line. I think that will almost guarantee that something gets missed.
Yeah, thank you, Sam. I appreciate that, and that's a great recommendation because I'm sure I didn't catch, like I was saying, in case something in rule section 6 applies to everybody. I think, yeah, drafting it broadly would be helpful, like you said. Thanks. Senator Hickman.
Yeah, thank you, Mr. Chair. I tend to agree with Representative Corey's assessment of this bill and this process. And I guess I'm wondering if it's my understanding that there are caregiver storefronts who also have a problem with the rules. And I just wonder how many of them agree to this particular approach, because it wouldn't necessarily affect them since they're not 100% home-based caregivers as the amendment proposes. Did we hear from a number of owners of caregiver storefronts who think that this goes far enough to help with the issues that they have with the program rules as proposed? That's just a question, I guess, for somebody.
Yeah, well, I can say that this would delay track and trace for retail caregiver storefronts until 2022. And it also more broadly says that you don't have to have video and security requirements for the caregiver dwelling unit, which applying it in rule section 6 would apply to all caregivers. So including ones who had a dispensary or a storefront on, so their house wouldn't have to have high security. But I haven't heard, to be honest, much in the way of opposition. I mean, or support from a retail storefront. Senator Farren.
Thank you, Mr. Chair. And I guess a question or an observation through Senator Hickman and maybe Representative Corey is, I mean, I hear what you're saying, and I've gone through this we've all seen the tons of emails and conversations we've had with folks about their concerns. But I'm looking at this particular piece of legislation to use our Senate Chair's analogy or as a backstop, is that we've got the eggs in the basket of a bill that we're going to work here in a little while that delays the rulemaking, and that could fail. We don't know where the chief executive, the rest of the legislature is, and I look at this bill here as some kind of compromise. And typically when compromise happens, not everybody's 100% happy. I heard a lot about the security piece. I've heard about the track and trace, the definition of the home, and we're someplace, because at the same time, we've seen these whole bunch of bills from some caregivers that want to expand the program and want to make it even more, open, and you can't have it both ways. There's got to be somewhere in between. So I guess this is, again, going back to Representative Corey and Senator Hickman. I look at this particular bill, no one's actually probably going to 100% like it, but it's better than the rules that we want to delay 100%. And it gives us, it gives something for the community in case the other things fail. And this is better than what the original rulemaking process is. So that's where I'm leaning towards trying to get down into the weeds on some of those questions and alleviate as much as we can.
And this process is the same process we would do next year if it were major substantive to that point. It's you take the rule, you read it, and then you direct them to make changes. So, I mean, I think we're doing it now through this as the backup. And then we can, if people want to try to delay it, we can do that in the other bill. Representative Corey.
Thank you, Mr. Chair. I'm really left with the belief that if we're creating a quote safety valve, that other bill is going to, fail. And especially if we're creating that safety valve because we're considering what we think that the chief executive, may or may not do. I'd love to see, the committee together on something, but I think by creating the safety valve you're talking about, we're just saying that other thing is not going to happen because I don't believe it would get signed then. And I believe that probably a veto would be sustained on that. So we can call it a safety valve, but what we're really doing is we're saying that we think that this is going to pass and that other thing stands at no chance of being passed. So I'm sorry to be so blunt, but I've done a lot of lawmaking over the last 7 years, and I've always felt that I should put the best policy forward and hope that the chief executive can recognize that policy. Thank you.
Right. I mean, I get that, and I just think it's a gamble with just one and going for it. We have two, we can take a shot. That's kind of where I'm coming from with this. But Representative Chiazzo.
Thank you, Mr. Chair. In light of Senator Hickman's question about the people with the caregiver storefront, I'm wondering, I think I see Mr. Pepin in the attendee thing, and I believe he is a storefront owner.
Yep.
So maybe we could bring him in and see what his thoughts are on the proposed amendment.
Okay.
You want me to put him in?
Yeah, I don't see him at the moment. Oh, okay.
I guess.
So, Mr. Pepin, did you hear the question from Chairman Chiazzo?
I believe it was in regards to the amendment.
Yes, that's correct.
Yeah, I caught the end of the question. I've been listening in for most part this morning. I've been in and out a few times, but in regards to the amendment, you are correct. I am a caregiver storefront owner. I am in support of the amendment. I don't know if you'd like me to elaborate more, if you have any additional specific questions, but I'm happy to answer.
Chairman Chiazzo.
Yeah, go ahead. Sorry, I was just going to say maybe you can elaborate on what the reasons you're supporting it, what things you find positive with it, because I think there's some question about, and again, I'll let Senator Hickman ask his own questions, but I think there was a question about what storefront caregivers thought of these rules because it didn't necessarily apply to them. It was more for the home caregiver.
I mean, I certainly see the amendment as a compromise. I think it does certainly reduce the burden on some of the smaller scale operators, which I do think is important, and it's a valid concern voiced by some of the smaller home-based caregivers. So, and the regulations as they pertain to caregivers operating storefronts, I feel are not overburdensome and they're reasonable. So I don't think it's going to be a detriment. I think it, like I said, it provides relief for those caregivers who are concerned on a small scale of some of the other provisions in the bill. And like I said, I think it's a compromise that I think makes good progress in all the effort that you guys are putting forward.
Okay. Thank you, Mr. Pepin.
Thanks. Representative Supika.
Thank you. I actually didn't have a question for Mr. Pepin. So if somebody else had a question, I'd like to defer, but I raised my hand before we started going down this path, and I kind of wanted to,
Sorry.
no, it's okay. It's kind of the flow of the conversation. But at one point I wanted to see if we could call in Michael Wilson and attendees to speak to kind of regulations and how regulations could push the black market side of things. But I did think of a question just now actually for Mr. Pepin. So if I may actually ask it. Mr. Pepin, you mentioned small caregivers. Do you have any like frame of reference of what you would consider a small caregiver, like in the industry?
I know this has been talked about a lot. I certainly think, you know, caregivers that are working out of their home, cultivating in a basement or some attached portion of their home, in my opinion, would be considered a small caregiver. You know, from a plant count perspective or from a canopy perspective, I think it's, you know, 100 or 200 square feet of canopy space, you know, not all 30 fully mature plants if they're on the plant count, maybe something like, you know, 12 plants or less if they're on the plant count. So those are my own personal assumptions.
Okay. Thank you. So just tonight, like kind of looking at canopy and plant count was, okay. So thank you for that. And then when I know other people might have questions, when we can call in Mr. Wilson to speak to regulations in black market.
Sure. Let me get Michael Wilson. Is that who you're referring to, Representative Speaker?
Yes.
All right. I will bring him in. Are there any other questions for Mr. Pepin? Senator Hickman, I don't know if you had questions for him or if you had a different line.
I do.
Please go ahead.
Thank you. Mr. Pepin, thank you for being here today. Can you just describe your business a little bit for us? And did you testify in favor of or against LD 1242 at the public hearing?
Yeah, nice to see you, Senator Hickman. So describe my business. I'd say a vertically integrated caregiver for the most part. Aside from providing or performing extractions for myself, there's a third-party licensed medical manufacturer that I use for that. But I cultivate and I have a storefront. Storefronts here in Wyndham, and my cultivation is on the 500 square feet of canopy. So I'm on my third year of having a caregiver storefront here in the town of Wyndham. I'm one of 9 stores in Wyndham, and I've seen that portion of the business grow solidly. So in regards to 1242, I don't know if I was present to publicly testify on that, Senator Hickman. So I don't recall whether or not I gave public testimony. But in general, I have been in support of the bill.
You've been in support of 1242. I thought I saw you testify on it. I just don't remember which bill you testified on because it was a long day. Are you currently cultivating for or have any interest in the adult use market?
I do cultivate. I'm owner of a company that has an adult use cultivation license with no retail on the adult use side. So just cultivating to wholesale to third-party retailers.
And as a cultivator in the adult use program, do you have to use the track and trace program?
We do.
Okay, thank you.
Thank you, Senator Hickman. Any other questions for Mr. Pepin? Senator Hickman, did you have a follow-up?
Mm-hmm.
No? Okay.
Not at this time, no, thank you.
Okay, no, sorry, your hand was still up. Okay, so we have Michael Wilson in, Representative Sapika. If you wanted to go ahead and ask your question, you're welcome.
Yes, thank you very much. So Mr. Wilson, I know that you have a PowerPoint, and I'm not sure if we are allowed to have PowerPoints presented by people coming in and speak. But I was wondering if you could speak to the concerns in the PowerPoint that you have and that other people have about regulations and diversions to black markets and how there's a correlation between the two.
Sure. First of all, I want to thank you all. I think that I hear a lot of people asking really good questions. And I think that a lot of you are really trying to dig to the heart of the matter, which I really I'm really impressed and I'm thankful for. The reason I put this together is because I think that the dynamic of how regulation affects black market activity or unregulated activity is not really being understood. And I think that's the reason that an economic analysis would really help in this case. And I think that's what's missing. I think if you look at the economics of the situation, you'll see what happens. And it's sort of really difficult to discuss really briefly, honestly, just because I'm pretty nervous to be on the panel. But I think it plays out in other states. And I think that is what has been seen as fact in history. And Maine has an opportunity to really learn from that and not do the same thing other states have done. And from my opinion, the fundamental problem with this regulation is that it really only affects the legal caregiver side of things. So it makes my business burdened with this strict regulation, which is a huge burden, which isn't the cost of the software or the cost of the tags. It's the daily interruption in my activities, such as weighing leaves and printing out these things all the time. It's a huge inefficiency to my business. And the reality is that we caregivers are sort of in competition with the unregulated market. And right now, in the last couple of years, you can see that that's been changing, and that trajectory will continue to change with the current rules. And strict regulation will literally reverse that effect. And I think that the heart of the matter, and I'll leave it at this so I don't take too much of your time, is that the regulations only affect the people who are already legally participating in the market, and it makes us less efficient. And that's what pushes people into the unregulated market, and it pushes buyers into the unregulated market. And it really leaves my business as a legal caregiver in a difficult position as a small business in the legal market. And that's the dynamic that plays out in states where the small businesses leave the market. If you go to Washington, there are no small businesses left, many of these states. And that's why legal caregivers are freaking out, because we know this is what happens.
Follow up if I may, Mr. Chair.
Go ahead.
Two things. One, I'm also nervous to be on this panel right now, so that's okay. And two, what would you consider to be like a small business in this industry? Like do you have, if you don't have an idea of that, but like when you say a small business, like what do you think?
I consider myself a small business. We're a husband-wife team. We have 5 employees, and we do operate out of a commercial facility. But it sounds like this big complicated thing to say we have a commercial facility, but literally we just don't grow in our homes. We live in Portland, and I think it's better that we don't live in our homes based on where exactly we live. I think that would be a huge interruption to our neighborhood. But the size of our business is the same regardless of whether or not I grow out of my house or not. So I would make the argument that anybody who's a legal caregiver is a small business. I'm just trying to figure out how to do payroll all the time and pay insurance and taxes and all of these things that small businesses have to deal with that I've never had to deal with before, and that I'm just figuring out. So when I look at other businesses that the state considers a small business, I would consider myself a small business, but I wouldn't really meet the definition that I just saw presented. I think that home-based, and regardless of where you grow, I don't think the size matters based on that. And if you're a legal caregiver, you really are a small business.
Thank you very much for that.
Okay.
Thank you, Representative Sapika. Representative Corey, did you have a question for Mr. Wilson, or is it different?
Yeah, it's a question for Mr. Wilson. Thank you for being here today, Mr. Wilson. You had mentioned being in competition with the unregulated marketplace. You're also in competition with the regulated marketplace, correct? I mean,
yeah,
if
100%.
And if somebody is, larger than you and more capable of having a lot of economy of scale and everything else in their business, they're going to want you to have the same types of rules, right?
Right. Yeah. And I think what happens, and you see in other states, the reason that the markets fail is, in general, the large businesses don't produce the same quality product. So you end up with, these big businesses producing products that not as many people want to buy. And that's the other dynamic that pushes people back to the unregulated market, is the middle producer, small businesses putting out the best product, aren't economically viable anymore. So you're right. It's competition from both sides.
Thank you, sir. I really like that wall color in your house. It's nice.
Oh, You can, my wife did that.
She did a great job for you.
Thank you.
Thank you, Representative Corey. Senator Hickman, did you have a question for Mr. Wilson, or is it a separate question?
It's for Mr. Wilson.
Please, go ahead, proceed.
Thank you. So welcome, Mr. Wilson. Thank you for being here. So you are a storefront caregiver.
No.
You are not. You do not
No.
have a storefront.
Nope.
Okay. So what is the nature of your business?
So we have a cultivation facility, and we used to basically do 100% deliveries, and then when 2018 came along, we were really on the verge of being unsuccessful, and that's when we were allowed to start wholesaling. So that was really what got us into real business, I would say, is being able to do that. We were supporting this caregiver thing basically with my wife's regular job. And now that we live in Portland, we really can't even, deal out of our house anymore. We're not allowed to do anything from the house because Portland has changed their local rules because they opted in. So now, we basically do delivery or, meet people at our farm or, other locations. That's sort of difficult, honestly.
So your business is primarily cultivation, but you do have patients that you deliver product to. Is that correct?
Correct.
Okay. Yep. And so the amendment that has been proposed wouldn't actually help you out. Is that correct?
No, I think for me, it changes the dynamic very little. I think it leaves the dynamic I'm scared of is what happens to the entire marketplace, not can my business individually burden this thing. It's the fact that you're really only affecting the legal growers, and this would have the same dynamic would play out. That's my fear.
So
and these don't help me.
So you said that in your opinion, all legal caregivers are small businesses. In Title V, Section 805 to subsection 5A, there's a section on rulemaking that has a clause on the impact on small business. And it says, for the purposes of this subsection, small business means businesses that have 20 or fewer employees. Do you think that that would be a framework within which you would want to see some exemptions from some of these rules, businesses of that size?
Businesses of 20 employees or less?
Right.
Yeah, that would.
One part of statute.
Yeah, we have a total of 5 employees, and I wouldn't anticipate us having more than 20 employees until if we ever decided to go to the adult use, if that became economically viable, which for us is not right now. That would be the only, that would absolutely help me. That's the answer.
And my last question is, do you agree with track and trace? If you do, why? And if you don't, why not? Based on your size of business and what you do.
Yeah, I absolutely don't. I think that anybody at my scale really sees no benefit from it. And the idea behind it, I think, is fundamentally incorrect. I think that the idea that it's going to get rid of the unregulated market or reduce it is just wrong. I think that it only increases it, and that's what we've seen in other states. And the reason is that it leaves people like me. It's like, you got a person who just went to high school and aced their algebra test, and now you're given a calculus exam, and it's so hard to implement that sort of system. My wife and I have, pretty professional backgrounds, and I've seen what it looks like, and I'm like, how am I going to pull that off and still run my business? And the answer is it's going to make me really inefficient. It changes my daily flow of what I do, and I would have to hire new people. So it just doesn't provide the benefit, because if it's for public safety, we can put batch numbers on there. And if it's to reduce the unregulated market, it's been shown to have the opposite effect.
Thank you.
Any other questions for Mr. Wilson? So, Mr. Wilson, if you could, I'm sorry, you said you're a cultivator, right?
Yeah.
Yeah. Okay. So yeah. I thought, if I understand Senator Lucchini's amendment correctly, if the amendment wasn't there, according to the OMP rules that are proposed, you would have to have video surveillance, lighting, and alarm systems. Is that fair?
I think that's what it says.
Right. And I'm just wondering, would you not qualify based on Senator Lucchini's amendment to not have those restrictions?
Right. I'm not home based. I don't.
Okay.
I don't remember them all, but when I was reading them, I'm like, okay, that's not going to apply to me. That's not going to apply to me.
Right, okay. Okay. Okay, thank you, Mr. Wilson. Any other questions for?
Thank you all.
You did a great job, by the way. So no, don't worry. That was real good. It was very good.
Thank you.
Okay. Any other comments, questions, concerns from the committee? Representative McCray.
Thank you, Mr. Chair. This, the conversation about small business versus home-based caregiver and looking at the amendment. Like, maybe this is a question for, I think you just left. Senator Hickman, are you still here? He's gone.
Yeah, I don't see.
I'm wondering if like I'm looking at the amendment in 1 and 2, if we talked about small business versus home-based, would that be a good idea, is what I'm wondering, rather than home-based caregiver? I see a thumbs up over there.
Yeah, yeah. Actually, Mr. Wilson, I got to take you out of the attendee role and put you back in the panelists if there aren't any more questions for you. But thank you for weighing in.
Yeah, I got a question for the committee. I thought that was interesting, and Siri's talking to me. I don't know what I asked her. I have that question. We're talking about a business using that definition that Senator Hickman shared of under 20 employees. Would that be a good change?
Representative Corey, did you want to take a swing at that?
I mean, I don't know how many caregivers actually would have 20 employees anyways. I mean, and I haven't really surveyed, that. When I look at sort of a lot of the way these caregiver grows work, it's essentially kind of, I just want to say, like the stacking of cards. Do you know what I mean? Like what they can do there with the number of, cards within their license. So, you have a caregiver and, they can grow 30 plants, and then sometimes they'll be working with another caregiver, typically, their spouse, like, was, mentioned by the previous panelist, so then you've got, essentially, 60 plants or 1,000, square feet. I don't know how many of these businesses or whatever get into 3 or 4 caregivers working together. I'm not sure what that looks like there. I've certainly been to one where I think that there's 3 different caregivers working together. So I'm not sure how many employees that is. And is it a number of employees per caregiver, working together? Or is it a total number of employees working, under one roof between 3 caregivers? I just, without a lot of discussion and a lot of talking to people, I'm not sure how to define what's large versus small within caregivers. I view caregivers based on what they're able to do, that being the 30 plants or 500 square feet, not necessarily, because I don't think with 30 plants and 500 square feet, you're talking about 20 employees, but I could be, completely wrong on that.
So before anybody goes on, I need to apologize to Senator Hickman. I moved him out of the panel accidentally when I tried to move the other attendee out. So I promise you, Senator, that was not intentional, and my apologies for that. So if you wanted to weigh in, please.
Go
ahead,
thank
Senator.
you.
And again, my apologies.
I do. I just wanted to say that the small business impact is in law for a reason as far as the rules are concerned, so that they don't negatively impact small businesses. And whoever came up with that number of having less than 20 employees put it in the law for a reason. And so if we are regulating caregivers as all other businesses are, then it would seem to me that trying to help them out would mean that they are small businesses if they have 20 or fewer employees. And therefore, we may want to consider a way to ensure that these regulations don't negatively impact them. Mr. Wilson's slideshow we received, I think under 2 different emails. And while we didn't show it today, I hope that we all look at it because it shows that in places where there are overburdensome rules and regulations on a certain size business, and all legal caregivers tend to be pushed out of the marketplace in favor of those that would be in the expanded adult use marketplace. And that is true in other states. So since we have that background to look at, that's one of the concerns that legal caregivers that are operating in the state of Maine as small mom and pop businesses are talking to us about. So it's not just the home-based caregiver, it's the caregivers of just about any size who may not even have a retail storefront. As we heard from Mr. Wilson, he's a cultivator that is legally allowed to perform deliveries with trip tickets to the patients that he has. His business will be negatively impacted by the rules, and the amendment doesn't actually help him out at all because he doesn't have a retail storefront, but he still is a caregiver who has patients that he delivers his cannabis to. So I'm just hoping that whatever we do, we're taking seriously that, you know, this is the largest agricultural commodity now in the state, overseen by VLA, not ACF. That's another story. And it's the second largest industry in the state. And it would behoove us, I think, as committee members to make sure that whatever we do can stop whatever they think the bleeding might be, should the rules that are in front of us go into effect. And LD 1242 is explicitly about putting a moratorium on those rules and coming up with a different way to go about having them be proposed in the future. So that's my way.
Yep, thanks, Senator Hickman. And again, my apologies, sir, for that before. Chairman Lucchini.
Yeah. Thank you, Mr. Chair. I think just after having watched, I mean, for a while, and sorry, I lost some internet for a little bit there. You know, maybe we need some more time on this to get more thoughts, but I mean, I do think people need to make the decision, I guess, within the industry, if they just want to just go for it or not have something that's kind of a backstop or not, because I mean, if I were in the industry, I would want a safety, I would want something to fall back on in the event that these don't make it across the finish line. So, I mean, it's something to think about. But if people wanted to table and do more thought and try to dig more into it, that we've been asking people to do for a few months now, and we would love to hear any thoughts specifically, you know, on problematic portions of the rule, not on the system as a whole and like broad overarching law stuff, but ways we can fix the rule so that we can make time for everybody to meet and then overhaul the entire program if that's where people want to go.
Representative Tuttle.
Mr. Chairman, I move that we would table this.
Okay, there's a
I'll
motion
second.
to table and seconded by Senator Lucchini. Let's see. So tabling motion ends discussion and debate. It's a non-debatable motion as well. So Karen, when you are ready, please call the roll.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
No.
Senator Hickman, no. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
No.
Representative Supika, no. Representative Wood.
No.
Representative Wood, no. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
No.
Representative Corey, no. Representative Dahlin. Representative Dolph, absent. 8 in favor of the motion, 4 opposed to the motion, and 1 member absent, Mr. Chair.
Thank you, Karen. Motion to table is successful. Senator Lucchini, I will turn the gavel back over to you if you wanted to proceed to the next bill.
Thank you, Representative Chiazzo. And I think, we've got all week, so we can take time to work through this. I don't think it's something we need to jam through today, given the issues that were raised. So another bill on our list. Senator Hickman, do you have a question?
Yes, thank you, Chair, because I couldn't debate a tabling motion. I just wanted to make it clear that I didn't have a problem voting out 1242 today. I think I said it before, I would like for a proposed change that's the backstop to just be a different vehicle than 1242, because I just think 1242 is great as is, and maybe there's 1319 or some other vehicle that could be the backstop that includes your amendment, Mr. Chair. That was what I was trying to communicate before we had the table motion. So that's all. This is for future reference. Now that we've tabled it, thank you.
Yep, no problem. And where 1319 is also very similar, I think it may be best if we just leave it on the table or table it also, and then figure out a strategy, I guess, for both of these, because if there is a two-pronged approach, it would probably be helpful to keep both alive and then kind of coordinate it in a way that people want. But that's just my thought. Representative Tuttle.
Yeah, Mr. Chairman, I move that we would also table 1319.
Thank you. Sorry, I'm sneezing today.
Well, I have that same cold, Senator Lucchini.
I'm allergic to everything. So we have a motion to table 1319. Is there a second?
Second.
Okay, motion to table by Representative Tuttle, seconded by Representative Chiazzo. Okay, Karen, can you please call the roll?
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
No.
Representative Supika, no. Representative Wood. Representative Wood, absent. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph. Representative Dolph, absent. 10 in favor of the motion, 1 opposed to the motion, and 2 members absent, Mr. Chair. Bless you.
Oh, thanks. Mute. Okay, thank you. Karen. Okay, next up we have LD 882. Which we have previously discussed before, I believe. So.
Let me pull it up and do a little refresher.
Sure, yeah, if you don't mind. I think this is one, we did get some helpful information from the industry that related to this as well. So just to make sure everybody knows that's in their inboxes. And I think from, I think Susan Meehan maybe sent that over.
All right. So as you all remember, this is LD 882, an act to amend the Maine Medical Use of Marijuana Act. This bill makes the following changes to the Medical Use of Marijuana Act, and it authorizes the Department of Administrative and Financial Services to do the following. 1, place an administrative hold on marijuana plants and harvested marijuana, or impose an administrative hold on certain registry identification card holders and registration certificate holders. 2, permanently revoke registration identification cards and registration certificates issued by the department. And 3, assess fines for misconduct by a registered caregiver, retail store, dispensary, manufacturing facility, or person authorized to engage in marijuana extraction using inherently hazardous substances up to $10,000. And it authorizes the department to assess fines for misconduct by registered caregivers or assistants or other authorized agents of a registered caregiver, retail store, dispensary, manufacturing facility, or person authorized to engage in extraction using inherently hazardous substances of up to $2,000. And as the committee may or may not remember, I just had a few kind of like technical edits or concerns with the bill, and the primary one was there's a provision that references that the fines that may be assessed under this bill don't prevent fines in other sections of law from being applied, and I think that could just be confusing language to have in the law, as in general that's the case, and if we write it here, it may imply that there are reasons we didn't write it otherwise. So I might encourage the committee to amend that piece if you're to move forward with this. So
Great.
that's all I have.
Thank you, Sam. Yeah, I think, again, there's so many different things impacting the medical marijuana from all angles, whether it's more regulation, less regulation. And this is something new, and we did get the document with some suggestions from the groups, which is great to have. Any questions on this, or for Sam? Or we can make sure people have a copy, if they don't, of the other document, just to make sure you can see the suggestions. I'm not sure if it's posted online where it came in through email instead. So it's something for consideration as well. And I guess any broad discussion, I think this isn't the most productive day, but if people aren't ready to go, I know I'm not ready to take these proposals as written, and I'm thinking we can hopefully find a middle ground or something that we can work on in the interim. Representative McCray.
Thank you, Mr. Chair. I'm looking for the document. Is it part of the big 18-page, or is it a different one? Okay, thank you.
Yeah, yep. I think it's at the end of the 18-page document. I've got it right here. So it's which came through email, so it may not have made it to the portal. Let's see. Yeah, I guess it's kind of in the middle of that.
I see it, page 14.
14, cool, thank you.
13,
if any member,
14.
yep, yeah, perfect. And if any members don't have that, we can make sure we get it out before we move ahead, because I know our emails tend to get buried these days. Representative McCray, did you have another question, or? No. Okay. Seeing that there's not a ton of discussion on this, if people want more time, we can do that. I try not to ever rush things through. We do have all week, so given the parameters given to us from the presiding officers. Representative Chiazzo.
Thank you, Mr. Chair. I'll make it the triumvirate and motion that we table LD 882.
Second.
Okay. Motion to table by Representative Chiazzo, seconded by Representative Tuttle. And if anybody has issues getting that document, just let us know. We can get it out to you. Karen, could you please call the roll?
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Piazza, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. 12 in favor of the motion and no one opposed to the motion and one member absent, Mr. Chair.
Thank you, Karen. Last up on the list, we have LD 939. An act to support Maine's medical marijuana program and ensure patient access. So Sam, can you give us a quick highlight of that? Sorry, and I know some of this one overlaps with the others as well, some of the other proposals, but.
All right. I hope everyone can see this now. So this is, as Senator Lucchini said, LD 939, an act to support Maine's medical marijuana program and ensure patient access. This bill makes quite a few changes to the medical program law. So I'll read through the summary just to highlight them all. But if you want me to stop at any point, just let me know. This bill allows caregivers to employ assistants who are between 18 and 21 years of age if they are also a member of the family of the caregiver, and clarifies that assistants hired by caregivers, registered dispensaries, marijuana testing facilities, and manufacturing facilities must otherwise be 21 years of age or older. It allows registered caregivers and dispensaries to transfer to and accept from another registered caregiver or dispensary an unlimited amount of marijuana plants and harvested marijuana in a wholesale transaction. It allows caregivers to accept a digital image of a written certification for the purposes of initiating a transaction for harvested marijuana, and requires the caregiver to verify the written certification in person before transferring any harvested marijuana to the qualifying patient. It allows registration identification cards and criminal history record checks to be valid for 1 year, regardless of employment status. It has a fee structure for caregiver cultivating based upon plant canopy. It repeals the prohibition on marketing marijuana plants or harvesting marijuana to any adult use marijuana market within the same sign, advertisement, or marketing material. It removes the provision allowing the Department of Administrative and Financial Services to adopt rules allowing advertising or marketing using location-based services if the marketing is a mobile device application installed on a device by the owner of the device who is 21 years of age or older, if it includes a permanent and easy opt-out feature, and provides instead that the Department of Administrative and Financial Services may adopt rules allowing advertising or marketing using location-based services if such marketing includes a permanent and easy opt-out feature and the owner of the device is 21 years of age or older. It changes the period of time registered caregivers, registered dispensaries, marijuana testing facilities, and manufacturing facilities must keep records from 7 years to 2 years. And it repeals the requirement that registered caregivers, registered dispensaries, marijuana testing facilities, and manufacturing facilities have annual audits by an independent third party. As a reminder to the committee, I have in the side-by-side in the following pages marked and highlighted in yellow where this bill overlaps with other bills that the committee has either passed or is working on currently this session. And I will also note, as I did before, that regarding this second bullet point, allowing the transfers between caregivers and dispensaries, that the bill as drafted is currently missing a necessary section to make this happen. So if the committee moves forward with it, and you want this piece in the bill, I would just recommend having it amended to include the dispensary section that was missed in the first instance. So I think that's it. Are there any questions?
Great, thank you, Sam. Any questions from the committee at this time? I know this one, we've had a number of bills and they can easily get confused. And just from a procedural standpoint, there is a motion about to pass as amended on this one from Representative Corey. Representative McCray.
Thank you, Mr. Chair. I had the question about municipal rules around opting in, opting out, and I see Kate DeFore is in the attendee room. I wondered if she could respond to that.
Okay, yep, we can bring in Kate.
I just brought her in, Mr. Chair.
Thank you.
I'll try not to demote Senator Hickman the next time.
It's once the boxes move, you just demote somebody by accident. It happens all the time.
Sure.
So, Kate, if you're, oh, there we go. Welcome, Kate.
Hello, how are you?
Good. I don't know if you had a chance to hear Representative McCrate's question, or Representative, if you wanted to.
Sure. Thank you, Mr. DeFore. I had just questioned when we talked about this bill before, just some clarity around the municipal options around opting in or not. And I wondered if you could go through that for me, because it seems, as I read it, it's kind of contradictory, but any clarity you could give would be appreciated.
So with respect to generally, I mean, all of these bills, from our perspective, we would like to retain the authority to regulate. And we retain that authority by retaining the opt-in, which is, it allows us, the communities and our residents and our ordinance development committees, the time necessary to develop those ordinances and then to opt in to providing or allowing an industry to establish shops within our boundaries. So that's important to us because we move when we're ready to move and not anytime further and not anytime sooner. If you do it the other way around, we have to immediately say we are opting out of this provision and coming back into the game or the industry when we're ready.
And a follow-up?
Yep.
Thank you. Does it make any difference what kind of operation it is? Cultivation? What about, the question came up around caregivers. Caregivers, my understanding was, are not regulated, but I'm getting information that they are. So could you help?
This is our perspective. We as communities' ability to regulate caregivers is pretty limited. We read existing law as being, how do I say this? I mean, we don't think we have as much authority to regulate caregivers as we do storefronts, cultivation, manufacturing. That's really clear with respect to our regulatory authority. When it comes to caregivers, it's pretty limited, and we are basically reliant on state statute to protect our interest in that avenue. That help?
Yeah, I might let it roll around a minute and I might come back with another question. Thank you. Yes.
Okay, Representative Chiazzo.
Thank you, Mr. Chair, and thank you, Mr. DeFore, for being available this afternoon. I guess maybe I'll try a similar question, but from a different perspective. If a community were to opt out, what would they not be able to pre-authorize, if that makes sense?
The understanding, the, see, if we want, so if under existing law, if we want to regulate the industry to the extent that we can opt in and we can regulate. Until the community opts in, the industry cannot come in into the community's boundaries unless otherwise established by state statute. And that has to do primarily with the caregivers. So opting out would allow anybody to come in and then the community acting after the fact. So opting out of the process. So again, we prefer the opt-in, which we advocated for strongly throughout both the medical and the recreational, in that it gives the community the time to decide whether or not they have the tools, they have the infrastructure necessary to regulate and invite the industry within their boundaries.
But if a community were to opt out, would they be able to restrict a caregiver, let's say a cultivator who wanted to grow on their personal property, from not growing because it wasn't zoned properly for that, even if the community had opted out?
If you opt out, I'm getting confused. It's like
So yeah, let me try it this way. So here, my understanding, and here's where I'm getting as equally confused as Representative, I think maybe Representative McCray is. So I've been told a number of different things by different people depending on which side it is. One thing I've been told is that if the community wants to authorize medical facilities, the zoning would apply to a storefront or a retail establishment, but it wouldn't necessarily apply to the cultivation side of things or a caregiver in their home, operating out of their home. So I'm not sure, and I'm hearing two different sides of that, right? So I guess what I'm looking for is what MMP's position would be on a situation where, for Scarborough, for example, where we have a moratorium on the retail side of things, but there are also grandfathered establishments in there that were there before the existing zone went in, so they're grandfathered, if you will. But are there abilities for municipalities to prevent growth until they're ready, if they do not opt in? Does that make sense?
Yes. So
okay.
The choosing not to opt in is the blanket of protection provided to the community. Unless the law prescribes that the activity can take place in the community over the objections of the community, then opting in is your time. It's the equivalent of a moratorium, except that it's not limited in time. When the community is ready to allow, the type of industry, then they can opt in, develop the ordinances, and start regulating that particular activity.
So if they're not opted in, then, for example, I'll use Scarborough again. If a caregiver wanted to become a cultivator, or somebody wanted to be a caregiver cultivator in Scarborough, starting off fresh right now, they would not be able to do that because the town has not opted in yet.
Correct.
Okay. All right. Thank you.
Sam, did you?
I just wanted to know if the committee would like me to pull up the local regulation portion of the statute, if that might be helpful.
Yeah, I think that'd be helpful. Yeah.
All right. Can everybody see this?
Yep, we can see it.
So I think it might be helpful for me just to read the first piece and then subsection 1, because that kind of introduces the landscape. So under section 2429D, local regulation, it reads that pursuant to the Home Rule authority granted under the Constitution of Maine, Article 8, Part 2nd, Title 30A, Section 3001, municipality may regulate registered caregivers, caregiver retail stores, operating pursuant to section 2423A, subsection 2, paragraph P, registered dispensaries, marijuana testing facilities, and manufacturing facilities. So there's the authority to regulate. And then under and then it proceeds that a municipality may not. And subsection 1 is prohibit or limit the number of registered caregivers. And so the rest of this section reads a little, it's a little hard to read, but essentially there are provisions about when municipal authorization is needed. And then this is my understanding is this is a grandfathering provision, basically saying that those who were operating prior to the establishment of the section don't need to regain authorization. So, how the municipalities feel about what they may or may not do, that's really what you should listen to them for. But I just would like to say, to show you for the purposes of the law, it appears that municipalities may regulate registered caregivers, but the big prohibition is that they may not limit the number or prohibit registered caregivers. So I hope that helps.
Representative Corey. Sorry, I think I'm frozen. Representative Corey. Did that go through?
Yeah. So, looking at the bill, and I look at what's in 939, and it doesn't really deal with home rule authority in any way. My understanding, sort of based on, bills that were passed in the past legislature, and Senator Hickman can correct me if I'm wrong, municipalities do have the ability to, I think, regulate the storefronts, like what's an actual storefront. But in terms of how many they'll have and stuff like that. But, in terms of anything else, 939 doesn't deal with whether or not municipalities can, limit the number of caregivers they are, because that's already established by, the state and in state law. I don't know why we're going over that in this bill, because as I look at the summary, nothing in the bill actually talks about the regulation of caregivers by municipalities themselves, and certainly not how many will be allowed in a municipality and everything. We'd have to change the current law as is. So there's really no grandfathering provisions or anything like that in the current bill 939 that we're dealing with today.
Senator Hickman.
Yeah, thank you, Mr. Chair. I was going to say something similar to that. The law was changed to respond exactly to the notion that municipalities wanted to be able to regulate storefronts. They could determine, we don't want more than 3, we only want none. I mean, they can't prohibit the number of caregivers, but they absolutely can regulate the number of caregiver storefronts. And so when the law was amended, it was amended to ensure that municipal approval would be required for the operation of any medical marijuana business that's outside of a caregiver home-based business alone. And so the municipalities do have a lot of authority to regulate right now. And in fact, in many of the ordinances that many communities are looking at around medical cannabis, it's the same, it's one ordinance. It's for both adult use and for medical. And so the streamlining, if you will, of municipal approval at the local level, because of home rule authority, localities are absolutely interpreting the law in their favor to ensure that what they want is all they get. And in fact, in the town of Winthrop right now, there's a municipal ordinance on the table because the provisions around the medical program seem to go above and beyond the intent of the statute. And so that's going to sit there until that's resolved, I think, in this town. I'm not exactly sure what's going to happen, but there is municipal ability for municipalities to do a lot of regulation in the medical program as we speak, because we changed the law to allow them to. So if you're hearing two sides, it's because some people were grandfathered and some people are not. So the people who were grandfathered, like, yeah, we're good. People are not grandfathered to start from scratch. They have to face the regulations that are in these local ordinances.
Thanks. And I think to Representative McCrate's issue, this was based on the testimony from MMA, I assume, that asked us to clarify the law, which is probably why it was raised, to Representative Corey's question. But yeah, Representative McCrate, yeah.
I'd just say it was raised because I was confused.
Yeah.
And it came up tangentially and seemed like a good place to ask the question. And we do a lot of that.
Yeah, we do. It's not an uncommon thing for this one bill. And they do ask for clarification in their testimony. Representative Chiazzo.
Thank you, Mr. Chair. Sam, could you bring up the 2429D again, please?
Absolutely. Might have to get back to it because I was moving around within the title.
It's in the chat.
Oh. Here you go.
All right. So I think this is part of my need for clarity too. So I don't see anything in section 2 or section 3 that defines a cultivator, or am I missing something?
A cultivator is not defined.
So yeah. I was asking Sam. I'm sorry. I was asking the analyst. Yeah.
Not in this section. No.
Are there other sections that would apply to cultivators?
I need to look through the statute before I can answer. Yeah. Sorry.
Yeah, and I don't mean to put you on the spot, Sam. So let me. I mean, if you want to stop sharing the screen, I'll try and explain what my concerns are, because part of it is the confusing message that I'm hearing from multiple sides, and that's fair. My concern is that, and I think I've expressed this before, and it's certainly not the most popular view of things, but you know, I think if we're going to allow, part of this bill removes the restriction for caregivers to wholesale. It'll allow them to wholesale 100%. And my concern is that if the caregiver cultivation side is I don't want to say unregulated, but if you don't need authorization for caregiver cultivation facilities, then there really isn't anything that I can see, unless somebody's going to point that out and tell me differently. I can't see anything that says a person can't become a medical cultivator because the towns can't prevent the number of caregivers from being there. It regulates storefronts. And then now they can do 100% wholesale, so they don't have the additional requirement of having to give 25% of that to a patient. So my concern with giving 100% wholesale to the caregivers, I'm worried that this is creating some kind of loophole that basically says they can cultivate wherever they like, and the local authorities it doesn't require local authorities to authorize that. So Sam, I guess that would be my question is, am I misinterpreting what that law says?
I don't know. I don't know if I can. I don't want to speak out of turn into in your interpretation. I just will say that I didn't want to speak offhand. I confirmed that we don't have a definition of cultivator in statute, but it is included under the under like the authorized activities by a medical marijuana provider that they may cultivate. And you know, as I read 2429D, it doesn't really address whether municipalities can prevent registered caregivers from cultivating or not.
Okay. All right. Thank you for that.
Senator Hickman?
Yes, thank you, Mr. Chair. So towns currently can restrict caregiver cultivation by zoning ordinance. I believe that's true in the town that the chair resides in. We don't have a definition for cultivation or cultivator in the Medical Act. We have a definition for cultivator in the Adult Use Act, because that's the separate thing that towns have to opt into. Now what towns are doing is that, this is what I said earlier, is that no matter what the law says, a town can require that a caregiver cultivate in an area zoned for caregiver cultivation. And if they say that they can't, then they can't. So the difference to me here is this. Formerly, a town could not say a caregiver can't exist. A caregiver cultivates cannabis for patients. Now towns are saying that if you are a caregiver and you cultivate for someone that is not your patient, you just can't do it. And so there's already ordinances that seem to run against the intent of the law. I just want to put that out there so people understand that that actually currently exists today. But to say that you can sell 100% wholesale from 75% doesn't necessarily just make you a cultivator. I suppose you could say that, but there's no definition for that. What it does do is it would, in my opinion, keep a cultivator, perhaps, who doesn't have patients that they deliver to or that they sell to in a storefront, to be regulated in the exact same way under the new rules. So I'm not exactly sure why people want 100% wholesale. I'll leave it up to the people who want it, but it's up to 100% wholesale, which basically means they can move between 75% and 100% to ensure that they're not having to divert their product into the unregulated market. And so we're giving them a legal way to dispense with that product. If they have too much and they don't have enough patients that are going to take it, they will find a caregiver or a caregiver storefront who can then use the product that they have grown for a particular condition to make sure that patients still have access to the medication that they grow. So allowing for them to sell up to 100% wholesale, to me, it continues to increase patient access to the kind of medication that they want. Because a medical marijuana cultivator is still working on strains that treat medical conditions and not just for the marketplace, for someone who just wants cannabis legally. And so there's always going to be a difference to me between someone who's cultivating under the caregiver model versus someone who may or may not be cultivating under the adult use model. It's about the kind of cannabis that is available to the patient. And so if you are in the caregiver business model and you have no intention of becoming adult use, you want the ability to perfect your strains for that particular marketplace. And that's what 100% wholesale does. It will not keep a municipality from regulating that cultivator away from that if their zoning doesn't allow for it. I hope that's not too confusing, but this is where home rule authority does this with statutory preemption. So the state says we preempt that you cannot regulate the number of caregivers, but towns are finding a way to do exactly that through zoning ordinances. And that's not prohibited in the law. So you talk about a loophole, there it is. Municipalities can regulate caregivers, even those who are only cultivating, not the other way around.
Representative Corey.
Thank you, Mr. Chair. I mean, I think that gets into a big reason why I support this, and I would agree with much of what Senator Hickman has said there. One of my concerns has always been that having that model where you have to sell 25% of your product directly to patients, it forces vertical integration. And I think that's a tough thing. You may be a really great cultivator, right? But then all of the other stuff might be kind of like a side issue for you, maybe something you're not good at, that's going to require you to, go out and, somehow, transform the product into something, put it, in an individual bag, probably sell it, set up some kind of a retail space and everything else. I don't believe that necessarily, everybody that may be good at cultivating, marijuana is also, good at all of those other things that, may be involved in the business. On the flip side of that, you're also, forcing somebody that may be good at working with patients and everything else to all of a sudden being in the cultivation business as well. And they may not, be green thumbs. They may not be good at growing things or processing things or doing things, as cleanly, like, for example, not dealing with mold in the ways that they should be and everything else. So it doesn't bother me, the idea of going to 100% retail or a cultivation model. Number two, I think that what we're also doing, at least since caregivers can be, in towns, and we have some grandfathered caregivers, as Representative Hickman has suggested. The biggest complaints that I ever got as a state representative from any of my constituents were constituents that had, before we had these caregiver storefronts, and in Wyndham we have caregiver storefronts, and I don't know how I felt about them at first, but now, as I've said in previous, work sessions, that, instead of, a line of cars being in a neighborhood on, a Thursday night or something like that, with people picking up their marijuana and all of the neighbors wondering what's going on there, that kind of activity is now happening in commercial areas, not necessarily neighborhoods where you have these cultivations. And when I talk about neighborhoods, I live in a town that was mostly zone farm for a while. It's growing quickly, but I would much rather push those sales activities, if it's more appropriate, out to those commercial areas, if that's what this would do. So 100% cultivation really doesn't bother me, at least as much as it did maybe 3 or 4 years ago, when I couldn't wrap my head around why we created these laws initially. Is anybody talking, or is like my thing just not working?
I was wondering if everything froze too, because nothing is moving on my screen.
I know I'm not talking.
Are we?
I did freeze. I think I did for sure, because I couldn't hear anything for a while. Sorry about that. Are we back functioning now? Okay, cool. Sorry about that. I don't know if it was just me or if everybody else could hear what Representative Corey said, but I lost. Probably, yeah. I have terrible internet right now. So Representative McCray.
I just wanted to say what Representative Corey said was absolutely brilliant, and it's too bad you missed it. I also just wanted to say I really appreciate the patience of Representative Corey and Senator Hickman, who have been dealing with this for years, with those of us who have not, and with the patience of a lot of the community who are trying to educate those of us who are not as educated, some more patient than others. And I know it's frustrating to have to repeat and reteach, but it's appreciated when it's done respectfully.
Thank you for that, Representative McCray. Agreed completely. And yeah, and I think that's kind of why we haven't been really rushing through a lot of this stuff through here. So to give people plenty of time and time to get input from everybody else. So okay, is there further discussion on this? Sam, can you kind of walk us through what the amendment was?
Absolutely. And Representative Corey, please correct me if I got my notes wrong. So my notes from the previous work session on the pending motion, which is ought to pass as amended. Sorry, my cat keeps getting in the way. Is that the amendment would make the following changes to the bill. So it would actually, to do this, I'm actually going to pull up my bill analysis, because I think having the bullet points in front of you might make it easier. All right. So my understanding is the amendment would do the following. First is it would remove bullet point 6 to not, so essentially it would not repeal the prohibition on the co-located marketing, that it would, in section 8 right here, it would amend the bill as drafted to change the record keeping requirement to 4 years instead of 2. That it would remove section 13 of the bill, which is represented here as bullet point 5, because that was already addressed in a previous bill this committee voted this session. And that it would make the requisite changes I had mentioned just to make sure that bullet point 2 actually does what it says it does. Is that everything?
Yes, that appears
That's
to be.
Okay, thanks. And so does this, do any elements of this, I guess, overlap with 1242? I was trying to think, does this do the audit thing that's in the other one as well, or?
So it does repeal the requirements that registered caregivers and registered dispensaries, marijuana testing facilities, and manufacturing facilities have annual audits by an independent third party. And to my recollection, they're both big bills, but to my recollection, I think that's the main place that they overlap. But I can review them again just to make sure.
Right. Thank you. No, it's hard to remember them all off the fly. And I think that's why it tends to be better to vote all 3 of these kind of simultaneously, because we're able to, like, this session seems to be the worst on on the number of conflicts between potential bills that we've had, because they're fairly large. But obviously that's up to people on the committee of what you want to do on each of these. Is there any other discussion? Representative McCray.
Just a question on the bullet point 5, the fee structure based on plant canopy. Is that bill all the way through the system, or we passed it, but it's not, hasn't gone all the way through? I don't think.
I don't think we've language reviewed it yet, have we? Oh, sorry.
No, I have not finished the, I just haven't had a chance to get the amendment ready for language review yet.
Yeah.
My question is, where it hasn't passed yet, but we support it, would it make sense to keep it here in case the other bill doesn't make it? Maybe that's a question for Representative Corey.
I think the other bill was unanimous, but I can't remember. Yeah, so the other one probably has the best shot of passage, to be honest. But yeah.
Thanks.
And I think my preference, though, obviously it's up to everybody, would be to keep working all 3 of these bills together so that we can do as much as we can to not overlap them in any way. But it's up to the committee on whether or not they want to move one at a time. Representative Corey.
Thank you, Mr. Chair. I mean, I understand sort of that because they're kind of confusing bills, but I don't think that this bill, touches on sort of that technical, rulemaking that's taking place. I think that with regard to that one last section about whether or not there's going to be those independent audits and everything else, I think that was just stuff that got put into those other bills as something that people didn't like. So they're like, let's put it in this bill that has to deal with either a moratorium or major substantive rule making. So I think we can take care of it here. And like I said, I don't think that anything else that these bills are touch anything in those other 2 rulemaking bills.
I would just say that the other 2 bills deal with rulemaking, but they also deal with a number of statutory changes, including the third-party audit, which could be about it, that overlaps, but they also have a fair amount of statutory changes, and like one of them repeals the electronic portal, they cap dispensaries. They do a whole lot more than just deal with rules. So, Representative Corey?
I
Yeah.
agree, but like I
Okay.
said, the only thing that touches both things is that piece with regard to the third party audits. I kind of think that this bill kind of stands alone on its own without, outside of that one area, but good, thanks.
Sam?
I just want to confirm that I did go back and look at 1242, and I think that the third party business audit is the place that is the one place they overlap.
Okay, thank you. And does this keep in, sorry, I missed it, the ID card thing?
I'm sorry, you mean the proposed change to go to a single identification card?
Yeah.
No, it's fine. I don't think 939 really addresses that. It has this, it does have the portion about using the digital image, but I don't think it otherwise addresses that.
Okay, gotcha. Representative Chiazzo, did you have your hand up? Sorry.
Yeah, I'm gonna have a hard time supporting the ought to pass as amended a motion. I mean, there's the record keeping issue. I know the department had some concerns with that from staffing. I've heard the discussions about wholesale transfer, but I'm still not quite there yet. I don't think I'm comfortable enough with that yet. Removing the audit without a track and trace system in place, I think is also probably not the direction I would like to move in. So I won't be making any motions, but certainly if we want more time to percolate this and try and get a better vehicle, I would support that. But the motion on the floor, I can't support the motion that's on the floor right now.
Yeah, and I'll just say I'm in a similar position where I think we should deal with all three of these at the same time. And so I probably am not going to support this as written until we, I think we can deal with it later in the week if people wanted to. Again, I won't make that motion. I can vote against it. But if people wanted to table it for more time, that's something that I've generally supported for every bill, just to see if we can build support around it. But okay. Any other Representative Corey?
Thank you, Mr. Chair. I'm just going to be frank and say I'm not going to move off of my motion that, this is what I'm good, with, I've thought about these things for a long time. As much as I, love to, kind of work with everybody on this, I'm really not going to change my mind on this. There's not a piece of information that will change, where I'm at with regard to this issue. Thank you.
Sure. I think it's also not just where you are, but where other people may be. Senator Hickman.
Yes, thank you, Mr. Chair. Like I said earlier, I wanted to vote out 1242 ought to pass, but so I don't mind if we table this or don't table it. I'm ready to vote whatever the committee's will is. I don't know that we, are going to find any too much overlap between this and that, but this bill and the others, because this bill changes some policy in the underlying statute that may or may not be affected by now the new rules or some future rules, but I'll just leave it at that.
Yeah, and like that, yeah, if we change the law, then that's fine with the rules. They can fix them accordingly. Representative Wood.
Thank you, Mr. Chair. I understand that these are all big bills about marijuana, but I'm sort of on the same track as Representative Corey. I'm good with everything in this bill except 9. We're told has some overlap, and I'm wondering if Representative Corey would take a friendly amendment to pull 9 out and let that go with one of the other bills.
Representative Corey. Yep.
Sure, I would do that.
So if I can, Mr. Chair, I'd just say I'm prepared to vote on this today. I just think we've got less than a week and we've got a lot of work to do. And I think the rest of this stands on its own.
Sure. So Representative Corey, you're good to change your motion to strike. Was it 9, Representative Wood?
Yes, I'm good. I'm
Okay.
good with that. That's the, piece surrounding the third party audit.
Okay. Any further discussion on this one? Okay, seeing none, I'll just weigh in. I'm going to vote against the pending motion. But I mean, I think with more time I could come on board, but right now I'm just not ready for it. So that's fine. We can do whatever the committee wants. So the motion before us is ought to pass as amended. And Sam, are you good on the amendment? Good to go.
I believe I'm clear on what it is, yes.
Okay, thank you. So with that, Karen, can you please call the roll?
Senator Lucchini.
No.
Senator Lucchini, no. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren. I can come back to Senator Farren. Representative Chiazza.
No.
Representative Chiazza, no. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
No.
Representative Tuttle, no. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney, absent. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. And Senator Farren, looks like he is absent. 6 in
Karen,
favor.
I'm here.
Oh, Representative Kinney.
Yes.
Representative Kinney, yes. So,
Okay.
7 in
Thank you,
favor
Karen.
of the motion, 3 opposed to the motion, and 3 members absent, Mr. Chair.
Great, thank you, Karen. So the motion of ought to pass as amended prevails. And anyone absent, I think will have until noon tomorrow to place their vote. Okay, and again, I think that, I mean, I could come to support things, but I would certainly need some time. Sam.
I just wanted to know what the minority.
Ought not to pass.
My fault. Yeah, I'll do odd not to pass for now.
Okay.
Yep.
And Kiaz will get, yep. Okay, I think, does that do it for you, Sam, today? Or, okay. I know we do have some budget stuff, so we can move on to that. Representative Tuttle?
Yes, Mr. Chairman, I'd like to wish Karen a happy 25th birthday. And I would sing you happy birthday, but I wouldn't make you have to listen to my off-tone voice, Karen. But happy birthday.
Thank you, Representative Tuttle.
Okay, well, thank you, Sam, for that. I think we can just, maybe we'll just take like a quick 3-minute break and then we'll come back in, just give people a quick break, and then we'll come back in and deal with budget stuff, which I think will be fairly quick. So take a short break. All right, we'll get started once we get people back. A few more back, and then
Do we have an agenda yet for tomorrow of what, or I assume we're meeting tomorrow?
yeah, no, I think at the moment we're probably not going to meet tomorrow, just because we have a lot of difficulties getting a quorum on Tuesday, Thursdays. So I think the plan will be just given last week at least. So I think the plan will be Wednesday and Friday for sure, and potentially Thursday if we need one in the middle.
Okay.
So we don't have a ton of bills left, but they are big bills and various topics.
Okay.
So yeah, I would definitely plan on Wednesday, Friday. Tomorrow's kind of up in the air, I think, because it's hard to have a substantive discussion on a bill if we aren't all able to do it because everybody's in different committees and things. So
Can I ask a question about next week? We're on June 2nd, we're in Augusta, but June 1st is Tuesday. Well, do you think there's committee meetings on Tuesday?
I think that the presiding officers could allow committee meetings to do it, but for some reason they've created these arbitrary deadlines, assuming we could finish as fast this session as we do on a normal session, which I think is a bit out there. But I think committees, typically committees can meet all the way through if they have to, but they're doing the permission thing, I guess, basically on whether or not we can meet.
Okay, thanks.
Yeah, so we'll see. I bet there'll be committees meeting, but it's hard to predict. So we try to schedule that way no bills just get left and die in committee. We want to make sure we don't put ourselves in that position by accident. Corey?
Thank you, Mr. Chair. The next week's going to be really challenging for me. Like instead of ramping down, we're starting to ramp sort of back up with the change package and everything else. So it'll be real sort of touch and go with me as to how much time I'll be able to spend in committee. I'll try to finish the work I've started. So
yeah. Everything's going to get pretty wild pretty soon, I think. Okay.
So what day are we coming in next week? Has it been the 3rd?
For session?
Yeah.
I think it's the 2nd. They
It's
sent
a
out a
Monday.
schedule. What's that?
All right. It's Monday then.
No, I think it's Wednesday, the 2nd.
Wednesday. Okay.
Monday's Memorial Day.
Yep, my wife told me Monday's Memorial Day, stupid.
my birthday.
Happy birthday, Pat.
All right, I think we've got enough people here so we can get ready to move on budget stuff. So I know we had voted, I think, each of the line items the other day, but there had been some conversations. Or Janet, do you want to explain to us where we stand at the moment and when we have to report back?
Certainly. So you voted on all of the portions of the actual change package itself. So there's one language portion and then several add these initiatives, take out these initiatives. You voted on all of them except the one involving the Gambling Control Board because it wasn't something we got any information about, and it seemed to be just a technical change based on the revenue forecast that I think members thought wasn't really something for the committee to weigh in on. But you do have until Tuesday, which is tomorrow at 4 p.m. to submit a memo. And I think there was some interest in maybe adding some language, so not directly about what's in the change package, but maybe some suggestions for AFA as well.
Sure. Thank you, Janet. And I think, and it is somewhat of an unusual process where the way that it's coming at us, but I know we had talked about veterans issues and the potential for adding, either an amendment to this that recommends appropriations funds certain projects. And I think that's an option that we can take if the committee's good with it. I know we've talked about prioritizing a couple of things, and one would be the kind of the mental health type of treatment program that we started a few years ago that ran out of funding, as well as the funding of veteran service officers. Senator Farron.
Thank you, Mr. Chair. And I think that those are some pretty strong things that we worked through this committee when we were talking about the supplemental budgets as well as the biennial budget. Now with this change package, I think if we send a pretty strong message, I know talking within my caucus, the caucus of one, that we do, that those VSO offices, as well as that permanent program, were very, very important pieces. We can talk about license plates and fishes licenses and park passes and all the other stuff, but those two programs were very important. I think if this committee was willing to send that, I'd be totally supportive of that.
Great. Thank you, Senator. Representative Corey.
Yes, and I'm sorry, but this session is a blur. We had bills that dealt with the VSOs, correct?
I have on both of those bills. I can show you if you want.
Okay, I mean, I think it probably, would be appropriate then for the committee to say, I mean, obviously these are things that are going to go, to the table, unless it's, a separate, budget item that's created for it. We haven't yet, voted. Have we voted on those bills yet? Have they been reported out, Janet?
Yes, so LD 658 was originally for 3 veteran service officers, and then you all amended it to provide funding for 2 veteran service officers, and that is on the special appropriations table right now. LD 693, which was the mental health case management services program, was passed to be engrossed as amended by this committee to keep that program going. It didn't make it all the way to the table, but I imagine that would be its next stop if more voting were to continue.
So how do we want to do that? Do we want to word a paragraph in there saying that we've got these 2 bills that are important to the committee on the table?
I think my preference would be to, if you try to amend a report back, would say that we think this should be included in the change package, because it's obviously far easier to pass something in a budget than it is to pass it off the table. I doubt we'll have money off the table. So, I mean, that would be, anytime we do amended budget report backs, it's typically for them to include it in the budget. Representative Corey.
So I don't have it in my mind, but we might want to check on that. For some reason, I think that change package had $30,000 for the, or sorry, not 30,000, $30 million for the table. If I recall, within the original budget, it was only, I think, like $3 million for the table or whatever the legislative priorities are. So I would definitely check. I agree that if if this is important to the committee, that, it's would be better, in the budget. But like I said, I think there's significant money on the table right now.
Representative Tuttle.
Yeah, Mr. Chairman, if it's appropriate, I'd put that in the form of a motion.
Okay, so I think the way it would form is like we'd add it in. And Representative Tuttle, are you saying that we would recommend they add this into the budget? I think there's some question there into the change package, I guess.
Well, I would defer to Representative Corey being on the Appropriations Committee, what he might recommend.
Sure. Senator Farron?
Yeah, I think my preference from what we've done in the past, I know said on appropriations, but I know from the committee standpoint, and Senator Lucchini, we worked on a couple of these bills to get some of these veterans funding in the past. And it was to try to do it through the budget process. If we do it to the table, we kind of lose a little bit of control from that standpoint, and we still might, but at least we're sending this message now. So as we're having those discussions, it can always fall back to the table. But I think trying to get it into the budget in the first place should be aim high and go for it.
Yeah, I agree 100%. I think getting it in the budget is the best way to do something. And then, I mean, even if the proposal started with a large amount for the table, that's still a proposal, and who knows if that's going to make it through. And if it doesn't get in the budget, then we can work for it to go through the table process. So, Representative Chiazzo?
Yeah, I was gonna concur with that. I'd rather put it in the budget and leave it on the table as we've used this term a lot today, as the backstop. I think no, I don't know how it will be received in AFA. We happen to have a member here, but I certainly would rather see that go on our committee report.
Okay, Representative Corey?
Thank you. And I don't know what reports are necessarily supposed to, entail, but what I'll explain the way the AFA process, works, at least, is that, we get these report backs from committees, we go through each, line item, in the budget and everything, things that have language associated with them, we'll eventually get to voting those things up or down. I think that unless there's some piece of language, and I don't know if Janet can correct me on that, I don't know how we get to the vote on that.
I wasn't here when you did the budget last time. I was out for personal reasons in the 129th, but my deputy director actually wrote that memo, and there was a DVM proposal that the committee felt strongly should move forward. It was LD 184, but I honestly can't remember what it was. I just remember the number. And so the budget memo was drafted as, we voted yes and no on all of these items, and we asked that you include a new initiative, and then it attached the bill. And it said we want this to be included as an initiative. And then if that, I think the backup plan is that if that doesn't get voted into the budget, then later when you're asked for the priorities about the table, you could say these are our number 1 and 2, or tied for first or something.
So it's like a proposed language amendment.
Right, and you just propose the actual bill or the amendment, whichever it may be.
Cool.
Right. I mean, I think I'm good with that, because appropriations will go line by line through the budget and vote for things, and it's a negotiation. So putting that on the list of items, I think, is the best way to go. Senator Farron?
Yeah, let's do that, knowing that we have a member of AFA that's going to point that out to them and say they're all in trouble if they don't follow this one. So we know on Representative Corey to carry that forward for us, and that'll be great. You won't let that sneak by.
Right, Senator, if he doesn't do that, we can always recall the other bill, send it back to the committee. Just joking.
So Representative Tuttle, are you good with the motion to recommend they put this in the budget through the letter, these 2 bills?
Yes, I am, Mr. Chairman.
Okay.
Second.
just to be clear. So motion by Representative Tuttle, seconded by Senator Farren. Any further discussion on that? Okay, seeing none. Karen, can you please call the roll? And a yes vote would be to move it in to the budget.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney, absent. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. 10 in favor of the motion, 0 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. And thank you, Janet, for walking us through that. And so I guess, you'll send that letter, I guess, procedurally to AFA tomorrow? Is that right? Or do you need us to do anything?
Yes, although it's on behalf of the committee, it's really like the from line is from you and Representative Chiazzo, so I'll run the language by you, and then once you approve it, I'll email it to the committee, and then it'll be sent by our administrative staff to AFA, however the appropriate way is, which I don't know off the top of my head.
Okay, thank you.
Janet, can you give me those 2 bill
Representative Corey?
numbers? Can you give me
Yeah.
those 2 bill numbers real quick again?
Yeah. They're LD 658 and 693. 658 is a strike and replace, so all you need is the amendment. So that's all I'm going to attach. And 693 is not a strike and replace, so you need the bill and the amendment from the committee to see what it does together.
Do you mind emailing those to me?
Not at all.
separately? Thank you.
Senator Farren?
Just before we leave, Mr. Chair, just a FYI, because we should have sent you the invite. We're having the Veterans Caucus at 8 o'clock tomorrow morning. And as the representative of the Democratic Senate Caucus, we would like to see you there.
Thank you. Yeah, somebody send me a link. I don't think I'm on your email group.
We'll get that taken care of. How could that be? How could that be?
Well, I'm not a veteran, so, but I'm happy, honored to participate. Representative Tuttle.
Yes, Mr. Chairman, I'd like to announce again that there will be a cookout at Senator Lucchini's place on Monday, wishing Representative Corey a happy birthday, Pat. So we're hoping you'll be there. That's at 1:30.
I'm out of town all weekend, thankfully. So
That's a wicked long drive.
Yeah.
I'll be there though.
I'm gonna be in Chiazzo's pool.
There you go. Yeah.
Okay, Janet, do we have any language reviews or anything we need to do, or are we good to roll?
I wasn't planning on any, so no.
Okay, great, thank you. So I think, Chris, if you're good, no meeting tomorrow, and then we'll meet Wednesday when we've got a better shot at quorum, and then after that, it could be Thursday, Friday as well. But yeah, just want to deal with all the bills. All right, great, thanks everybody. Have a good afternoon.